Before initiating divorce proceedings, it's essential to determine whether the Singapore courts actually has jurisdiction over your case, understanding the difference between an annulment and a divorce. Here are 7 things you need to know about getting a divorce in Singapore. Here are 7 things you need to know about getting a divorce in Singapore. Number 1, jurisdiction and eligibility. Before initiating divorce proceedings, it's essential to determine whether the Singapore courts actually has jurisdiction over your case. Here's what you need to know. To file for divorce in Singapore, either party must meet one of the following criteria: be domiciled in Singapore at the start of the divorce proceedings, be habitually resident in Singapore for at least 3 years before the divorce begins. Parties must have been married for a minimum of 3 years of marriage. Exceptions may sometimes be made in a case where one person has suffered exceptional hardship or cruelty. Number 2, understanding the difference between an annulment and a divorce. It's important to distinguish between the two. A divorce legally terminates a valid marriage. After divorce, both persons are considered to have been married before, and the marriage is now dissolved. An annulment is a legal declaration that the marriage has never been valid from the beginning. It essentially erases the marriage as if it never existed. Number 3, 2 stages in a divorce. A civil non-Muslim divorce in Singapore involves 2 main stages. Stage 1, the dissolution of the marriage. The party seeking a divorce must establish the grounds for divorce, which is the irretrievable breakdown of the marriage. This can be proven through 4 facts, namely, number 1, adultery, number 2, unreasonable behavior, number 3, desertion, and number 4, separation. Each reason must be proven in court unless both parties agree on the grounds for divorce. Stage 2, the ancillary matters. After the marriage is dissolved, the court can address the ancillary matters, including custody, care and control, and access to children. Number 2, maintenance for the wife and children. Number 3, division of the matrimonial assets. Next, number 4, ancillary matters including custody, care and control, and access to the children. Custody. This involves significant life decisions for children, such as education and religion. Care and control. This determines the primary caregiver and where the children will reside. There's also access, and this defines the visitation rights of the non-custodial parent. Husbands are generally required to provide maintenance for their wives and children up to the age of 21. Maintenance agreements can be reached between parties or determined by the court based on various factors. Matrimonial assets are divided based on direct and indirect contributions to their acquisition. Factors considered include financial contributions, debt obligations, and other forms of support. Number 5, uncontested divorces. Most divorces in Singapore can be conducted on an uncontested basis for a number of reasons. Trials only occur when there's a dispute of fact, and trials can be costly and time-consuming. Proving one party as wrong doesn't always end with a significant advantage. Parties often prefer an amicable resolution, especially when there's children involved. Number 6, the role of lawyers in a divorce. Although you can file for divorce without having a lawyer, be aware of the procedures and complexities involved, and you must file such documents, including the writ of summons, the statement of particulars, on your own. Number 7, procedure in divorce cases. Step 1, dissolving the marriage. Serve your divorce documents on the respondent. The respondent has then 8 days to respond or contest, and if contested, the case may proceed to a trial. Mediation or counselling can also be encouraged, and if uncontested or after mediation, the court may grant an interim judgment to dissolve the marriage first. Stage 2, ancillary matters. Both parties disclose their financial assets and liabilities, and if the total net value of the matrimonial assets exceeds $5 million, the case will then go to the High Court. After documents have been exchanged, the court will then schedule a hearing for the ancillary matters to be decided. Parties must wait 3 months from the interim judgment before applying for a final judgment. So now you know. If you found this helpful, follow and subscribe to our channel for more legal things.